Hi, I'm Judge Steve Austin, Superior Court of Contra Costa County.
And I'm Judge Erica Yu, Superior Court of Santa Clara County.
Judge Yu and I are very much involved in the statewide spoken language access effort. I'm a member of the Language Access Plan Implementation Task Force, which Justice Cuellar chairs, and I'm also the chair of the Court Interpreters Advisory Panel.
And I'm a member of the Judicial Council Advisory Committee on Providing Access and Fairness, and a member of the California Commission on Access to Justice. In addition, I and Judge Daryl Mavis from Los Angeles recently developed and taught a new course on spoken language interpreters at the 2015 Judicial College.
We would like to spend the next few minutes providing you with a brief update on the efforts of the Language Access Task Force, as well as a review of the processes and procedures which all court proceedings are now subject to, including new requirements resulting from the enactment of AB 1657 and AB 2370 this past year, as well as several Judicial Council policies and rules of court which are being developed.
Our overall goal is to familiarize you with the requirements and walk you through the key procedures you should follow in criminal and juvenile delinquency proceedings. We will also offer some procedural options you could follow during this interim period before the Judicial Council has revised the relevant rule of court and forms. We also want to provide you with additional resources that you may need for follow-up.
Providing language access to court users is a frequently encountered issue, and it is of critical importance for the state and the branch with respect to our obligation to provide access to justice for all court users. This was the primary motivation of the Judicial Council to adopt the Language Access Plan, that's the LAP, on January 22, 2015. The LAP, together with recent legislative enactments in 2015, significantly increases the branch's commitment to providing language access. In summary, the LAP has 5 broad goals. 1, we are seeking significant additional funding for trial courts in the area of language access. 2nd, we are developing guidelines to assist the courts in creating local language access representatives or offices. 3rd, we are developing a detailed work plan and cost estimate for full LAP implementation. 4th, we are developing a statewide model regarding available language access services as well as a model complaint form and process. And finally, we are working with CJUR in developing education and training for both judges and court staff in this area to ensure a successful implementation of this overall effort.
A centerpiece of the LAP involves expansion of interpreter coverage in civil proceedings. Effective January 1, 2015, Evidence Code Section 756 was added to expressly authorize courts to provide interpreters in civil matters at no cost to the parties, with prioritization by case type and preference within some case types for indigent parties. This prioritization was required due to the limited funding available for interpreter services. It is one of the goals of the Language Access Plan that by 2015, and beginning immediately where resources permit, qualified interpreters will be provided in the California courts to limited English proficient court users in all courtroom proceedings, and by 2020 in all court-ordered, court-operated events.
Under Government Code Section 68560, a court proceeding includes all court proceedings with the exception of small claims. What this means is that all civil, criminal, family, and juvenile court proceedings are subject to statutes that require courts to use certified or registered interpreters to interpret spoken languages. There is a good cause exception provided in the statute, and we will explain that in more detail in a moment.
Who is allowed to interpret in a court proceeding? It must be remembered that whenever you allow a person to interpret in any court proceeding, you are in fact appointing that person to be an interpreter, and there are procedures which must be followed pursuant to that appointment, depending upon the type of proceeding, the spoken language involved, and the credentials or lack thereof of the proposed interpreter. Broadly, the Government Code requires court interpreters to be certified or registered, unless the court finds good cause to appoint an uncredentialed interpreter. The distinction between a certified and registered interpreter depends on if the language is one of the 14 currently designated languages requiring a certified interpreter, or if the language is not currently designated, requiring a registered interpreter. In both cases, the court must have on the record the person's name, the badge number, and a verification of the interpreter's credentials, the language to be interpreted, and a statement that the oath was administered or that it is on file.
If an appropriately credentialed interpreter is not available, courts are able to appoint what is termed a provisionally qualified interpreter, and this is where the good cause exception mentioned earlier comes into play. A provisionally qualified interpreter is usually an experienced interpreter who is neither certified nor registered. As we will explain in a moment, the process is not appropriate for the appointment of a friend or family member to interpret because the procedures entail court staff to undertake activities in advance of the court proceeding. And under no circumstances should a minor be used to interpret in any court proceeding. Sections 68, 561, C and D permit a court to appoint someone who is neither certified nor registered only for good cause and only when the court has followed the procedures and guidelines adopted by the Judicial Council.
These procedures are found in Rule 2.893 and in the Judicial Council forms INT. For criminal and juvenile delinquency materials, the court must fulfill these procedures as evidence of conducting a diligent search for a qualified interpreter and establishing the qualifications of the interpreter to be provisionally qualified by the court.
What Eric and I want to emphasize at this point is that even though the existing procedures and guidelines stated in Rule 2.893 of the California Rules of Court and the Judicial Council INT forms currently apply only to criminal and juvenile delinquency proceedings, the Judicial Council is currently developing revisions to this rule and to the forms to accommodate the expansion of interpreter services to all court proceedings, as we discussed a few moments ago. These revisions are expected to be adopted in 2017. In the interim, one option could be to follow Rule 2.893 and use the existing INT forms for all case types pending their revision. I would find this to be an effective approach until rules and forms for civil are developed.
Returning to the nuts and bolts of these procedures, typically it is court staff who complete these procedures and forms. So it is important to schedule this activity in enough time in advance for the proceeding where the provisionally qualified interpreter is to be used. And judges should know that they have to give the interpreter, whether the interpreter is certified, registered, or provisionally qualified, time with the person needing the translation so that they can check register, dialect, and so forth.
Rule 2.893 also provides a very limited exception to allow uncredentialed interpreters who have not been provisionally qualified to interpret in criminal and juvenile delinquency proceedings under very limited circumstances. This situation usually arises for brief and routine matters when one of the parties in the proceeding has requested the interpreter and the appointment will avoid an unreasonable delay in the proceeding or when there are other unusual circumstances. And the judge is expected to make certain findings on the record.
When allowing an uncredentialed person to interpret under this very limited exception, the judge must find on the record that the party has waived the appointment of a credentialed or provisionally qualified interpreter. The judge must also find that good cause exists to appoint the requested interpreter. Good cause can include factors such as avoiding a burdensome delay or other unusual circumstances of the proceeding. And the judge must find that the person is in fact qualified to interpret in the proceeding. These findings will apply only to the instant proceeding and will not be extended to any other proceeding. Finally, if the person is uncredentialed, not provisionally qualified, and the limited exception just detailed is not present, that person is not able to interpret in the proceeding. And as Judge Austin has already mentioned, children should never be used to interpret. I know from my own experience as a child and interpreting for members of my family how stressful that can be.
But what if there is no court reporter? How can you make a finding? We have some recommendations which, if followed, would preserve the statements that the judge is required to make under the Government Code and Rule 2.893. First, if the proceeding is being recorded, the judge could make the required statements in open court during the recording of the proceeding. Second, if the proceeding is not being recorded, the statements could be stated in open court and taken down in the court's minutes, minute orders, or court file so that they can reflect what was stated in open court.
And as a third option, the clerk could prepare bench cards that are tailored to the specific proceeding and retain them as part of the court file. We know what Steve and I have just reviewed may not cover all the situations you will encounter at your court, and we appreciate the delays which may result as you strive to find qualified interpreters for your cases and proceedings. We can assure you that these situations will become far less frequent as we fully implement the expansion of language access services over the next couple of years.
Judge, you and I know that this brief presentation and discussion regarding the appointment and use of spoken language interpreters does not answer all of the questions or inquiries you might have. To that end, the LAP Task Force is developing a series of useful resources, including a web-based living toolkit and other web-based resources. In the meantime, we currently have an FAQ document, which is very helpful, as well as an email address where you can send inquiries about California's language access efforts. And in any event, please don't hesitate to contact me about anything regarding this critically important effort. Thank you.